question about the whole notion of the CIO working with the general counsel. Is that pretty common practice for general counsel to call up and be like, what about Section 3? And for them to expect the CIO to know that, to have looked at Section 3?
I was just going to say that when we were discussing, based on the beginning portion of this case study, when it said that the role of the CIO was to sort of serve also as a marketing agent to try and help push the contract through the company, we sort of thought it was safe to presume that at some level the CIO, if legal was the big holdup, was going to be having some type of communication with the legal department if they were the key agent pushing it through. So I think that's what we were going off of there.
I mean, I think this goes, oh, go ahead.
And actually, I think we got that example from Jenny last week. So at least I think Jenny's been in that experience.
I mean, again, it goes to kind of the crux of our concern in terms of which is better. Is your document, which seems to be more simplified, but it's one thing, better than the summary with the contract? And I mean, that's, again, it's still, we're still sitting here and
I mean, and this one got bigger. Like
this one did get bigger.
Yeah.
It did get bigger.
Yeah.
But we also think it's clearer, than it was last week. I think you probably could walk away with doing a skim read on the current one and have a better idea of what's going on with it. And I think another thing that really motivates to do one document that was longer was just that I think someone, maybe it was Jim, maybe someone else made a comment about, we're a law firm, not necessarily like a marketing firm, so we're not going to make you a nice summary that is marketable, but we are going to make you like a legal document. That's what we should be offering you. So, and I think our other concern was that we were just thinking about it in terms of the way if this ever gets sued on, it's going to be some sort of evidentiary record, right? So you don't want to leave things out of it, and you also don't want multiple interpretations of it floating around. So we thought it'd be best to have only one statement of your party's intent as opposed to, multiple different documents that can be read against each other. And the more ambiguities you have, the more trouble you can get down the line.
I'm going to have to actually disagree with Alex. I think as lawyers, we're in a position to be able to translate this language into something that's more understandable. And I think that somebody who's not familiar with this language wouldn't be able to do that. So I'd have to disagree on that point. I do think we're in a position to not create a marketing tool, but create a document that explains this legal document in an easily understood format.
A benefit of the summary that we haven't also really discussed is we kind of are working on the assumption that this one person, this CIO, makes this last call, and he's the only person who needs to sort of feel this momentum in order to push this through legal and get this signed. But I would say that a benefit of the summary would be that it would be easily forwarded to other decision makers or other people who aren't necessarily attorneys to have an understanding of this, and then you could build this momentum within a company that way by sort of spreading the word, but through something, I wouldn't really think that a 9-page, 10-page, 12-page contract could be easily passed on at lunch or something about, you should read this, this is really interesting. Instead, a summary could be passed off and actually create that internal momentum.
And I kind of want to add to that, it's kind of like when you look at this, there's higher order concerns and there's lower order concerns. And you guys are CEOs, you're idea people, you're into the higher order concerns. You want to sit down with someone and be able to explain your enthusiasm and have them get it. We're the legal department, we're dealing with the lower order concerns and stuff like indemnity and how that's going to affect your business. So what the summary does is it gives you the bridge between those two things so that you can sit down with the CEO or CIO and you can say, look, these are where we're connecting on the higher order concerns, and here's a quick 2-page document about how those lower order concerns will affect your higher order understanding, right? And then they can pass it on to the legal department, and hopefully, the legal department will come back to them and say, well, have you seen this provision? The guy can say, I understand how that is going to affect our relationship, and it's okay, keep going, push it through, I want to get it done.
So here's my thing, though, is if that summary isn't part of the contract, the CIO of any major corporation or CEO or whoever you're talking to is going to turn around and say, I got to send this through legal. And then the real question is any of these contracts that we have in front of us, the revised contracts, are any of these going to make it go faster?
I think we stand behind our revisions that we think ours would. I mean, we substantially revised section 3 just to make the actual process of innovation possibly a little more understandable.
And there's a distinction. The fact that the summary is not the contract doesn't mean that it doesn't synthesize well. You know, we really took care to make sure through footnotes and, you know, each line saying that this is what's in the summary, this is what's in the contract, and that syncs up. We're just saying that, you know, to make something more clear, we might have used a verb or an adjective that's a little bit different than in the contract, and we just want to make sure that we're not sitting in court saying shall and may, and, you know, so the contract itself is the full contract.
Who's
the
on the
summary
line?
does sync
Who's
up.
on the line when that happens then?
Who's on the line?
Well, if it's not binding and that does happen, it's still up for interpretation.